Sheriff's Department, open the door now.
Do you have a warrant? I'm an attorney. I know my rights.
We have authority under active investigation. Open this door or we're coming in.
I'm a United States citizen. Show me a warrant or leave my property.
Dr. James Carter's doorbell camera captured the exact moment when Sheriff Kevin Dawson and his heavily armed tactical team positioned themselves at his door at 6:47 on a Tuesday morning without a warrant, without warning, and without any legal justification that would withstand scrutiny from a first-year law student. James was inside having coffee and reviewing notes for a federal case he was arguing that afternoon, completely unaware that in the next few minutes his home would be invaded by 8 armed officers with assault rifles treating his peaceful residence as if it were a dangerous drug dealer's den. What Sheriff Dawson didn't know, what none of the officers behind him knew as they prepared to break down that red door, was that the black man on the other side wasn't just an ordinary citizen who could be intimidated into silence, but rather one of the state's most respected constitutional lawyers, someone who had dedicated 20 years of his career to suing police departments for exactly this type of flagrant Fourth Amendment violation. What happened in the next 2 hours, all documented by multiple cameras and eventually costing the county over $1 million in settlements and forced reforms, would become one of the most spectacular examples of law enforcement choosing absolutely the wrong person to harass. Before diving into this story that will show what happens when police incompetence meets expert legal knowledge, tell me, where are you watching from? If this is your first time here, hit that subscribe button and leave a comment about what you think should happen to officers who invade homes without valid warrants, because this story will give you a front row seat to justice being served in its most satisfying and expensive format. James Carter was 47 years old and had built a formidable reputation as a civil rights attorney, specializing in Section 1983 cases against police misconduct, unconstitutional searches, and excessive force. He had won dozens of cases against law enforcement departments across 3 states. His arguments cited in circuit court appellate decisions. His litigation strategies taught in law schools as examples of effective civil rights advocacy. Prosecutors and municipal attorneys across the region knew his name and dreaded seeing it listed as opposing counsel because they knew he was meticulous, relentless, and extraordinarily successful at holding officers and departments accountable for constitutional violations. He had written 3 books on Fourth Amendment rights, lectured at national law conferences, and served as an expert consultant on high-profile cases involving warrantless police raids. He lived in a modest but well-maintained suburban house in a middle-class neighborhood, chosen specifically because it was quiet and because it was only 20 minutes from his downtown office. The house had a comprehensive security system, including doorbell cameras at front and back doors, security, cameras covering the driveway and side yard, and monitored alarm system connected to a private security company. James had installed these measures not because he feared crime, but because as a lawyer, frequently dealing with hostile law enforcement, he understood the value of documenting everything that happened on his property. That investment in surveillance was about to pay off in ways he never anticipated when he installed the cameras 3 years earlier. Sheriff Dawson had arrived at James's property based on what he would later describe as reliable anonymous information, suggesting the residence was being used to store illegal drugs. That information was vague at best and completely baseless in reality, but Dawson had decided it was sufficient to justify what he called a knock and talk, a term law enforcement uses when they want to make forced entry onto private property without a warrant seem like somehow benign routine procedure. He hadn't bothered to obtain a search warrant, despite having ample time to do so if he really believed there was probable cause. He hadn't checked property records to see who lived in the house. He hadn't conducted basic surveillance to determine if the anonymous information had any merit. He simply decided to show up with full tactical team of 8 officers armed to the teeth and demand entry based on nothing more than an unverified hunch and apparently the assumption that the resident would be too intimidated to refuse. The doorbell camera showed Dawson ringing the bell once, waiting maybe 10 seconds, and then knocking on the door with enough force to make the entire frame shake. James heard the noise from his kitchen and walked to the door, looking through the peephole to see what initially seemed like a small army camped on his porch. He could see tactical uniforms, bulletproof vests with sheriff written in large letters, and assault rifles held in low ready positions that seemed absurdly excessive for a routine morning. knock at a peaceful suburban neighborhood. His first thought was, there had to be some mistake, that maybe they had the wrong address, that no rational law enforcement department would send a SWAT team to a civil attorney's house without extraordinary reason. His second thought, based on years of experience seeing how law enforcement operated, was that he needed to start documenting everything immediately, because whatever this situation was, it probably wasn't going to end well without clear evidence of what actually happened. James pulled his cell phone from his pocket and opened video recording app before disabling the security alarm and opening the door partially, leaving the security chain in place. He calmly identified himself and asked how he could help the officers, his voice professional and courteous despite increased heart rate, because having 8 armed men on his porch at 6:47 in the morning wasn't exactly a scenario-inspiring calm, even for someone with his training and experience. Dawson responded saying they had information about illegal activity at that address and needed to enter to check the premises. James asked to see the search warrant, a basic question any citizen has the right to ask, and that a lawyer would definitely ask when confronted with a request to enter private property. Dawson's response immediately revealed this wasn't a legitimate police operation conducted within constitutional boundaries, but rather what James instantly recognized as an intimidation attempt, based on assumption the resident would be too ignorant or too frightened to demand his rights. Dawson said they didn't need a warrant because they had probable cause based on information they received, a claim that was legally absurd, and that James knew was absurd because he had spent 2 decades arguing cases involving exactly this issue. Probable cause doesn't eliminate the warrant requirement, except in very specific exigent circumstances that clearly didn't exist here. There was no emergency, no evidence being destroyed, no suspect fleeing, none of the narrow exceptions that would permit warrantless entry into a residence. James responded calmly but firmly that without a warrant or articulable exigent circumstances, they had no legal authority to enter his home, and that he was denying consent for any search of his property. He said this in a clear voice captured both by his own phone recording and by the doorbell camera continuing to document everything from the external angle. Dawson's expression visibly changed when James denied consent, shifting from authoritative confidence to something like frustrated irritation. He repeated they had reliable information about criminal activity, and James was obstructing a legitimate investigation by refusing entry. James calmly responded that denying consent for a warrantless search wasn't obstruction, but exercise of constitutional rights protected by the Fourth Amendment, and that if Dawson really had probable cause, as he claimed, then he should have obtained a warrant from a judge before showing up at his property with a tactical team. The doorbell camera perfectly captured the exchange, showing James standing calmly behind the partially open door, while Dawson became increasingly agitated on his porch, the other officers behind him starting to exchange uncomfortable looks as if realizing this situation wasn't unfolding the way it normally did when confronting ordinary citizens. Dawson then committed what would be the first of several critical errors that would transform this incident from illegal harassment into complete legal disaster for him and his department. He told James that if he didn't open the door voluntarily, they would have to assume there was something illegal inside and would enter anyway. James immediately responded that logic was constitutionally backward, that refusal to consent to a warrantless search couldn't be used as justification to conduct that very search, that this was established in decades of Supreme Court jurisprudence, starting with cases like Florida versus Jardines and Illinois versus Rodriguez. He was citing specific cases from memory, demonstrating a level of legal knowledge that should have made Dawson pause and reconsider his course of action. But instead, the sheriff seemed to interpret James's legal knowledge as a challenge that needed to be overcome, rather than a warning he was about to violate the rights of someone who knew exactly what those rights were and how to hold officers accountable for violating them. That's when Dawson made the move that would transform this questionable stop into unequivocally illegal invasion. He waved over 2 of the tactical officers, who approached with a portable battering ram they had apparently brought, anticipating they might need to force entry. James saw the equipment and immediately warned Dawson in a loud, clear voice, captured by multiple recordings, that any forced entry without a warrant or exigent circumstances would constitute Fourth Amendment violation, that he was a constitutional attorney specializing in suing police departments for exactly this conduct, and that if they proceeded, they would be creating massive legal liability for the county. He literally said, "My name is Dr. James Carter. I'm a constitutional lawyer, and I'm warning you what you're about to do is illegal and will cost the county dearly." But Dawson either convinced James was bluffing or simply too arrogant to believe he could be. Held accountable, gave the order for his officers to proceed. The battering ram hit the door once, twice, 3 times before the security chain broke and the door swung fully open. James backed away quickly, his hands visibly raised and empty, his phone still recording as 8 officers rushed into his home with weapons drawn. Internal security cameras captured everything from multiple angles. Officers shouting contradictory commands for James to get on the ground, stay where he was, put hands behind his head, creating that confusing chaos that often characterizes tactical entries and can easily escalate to violence when a suspect can't physically comply with simultaneous conflicting orders. James, with remarkable presence of mind given the circumstances, did exactly what he knew he should do. He lowered to the floor slowly with hands behind his head, clearly stated he wasn't resisting, but continued to deny consent for the search, and asked to speak to a lawyer despite being a lawyer. Himself, because he wanted to establish for the record he was invoking all his constitutional rights. Officers handcuffed James and sat him on the couch of his own living room while they began searching through his house. Dawson remained with James, apparently still convinced he would find evidence that would retroactively justify his illegal entry, operating under the legally flawed theory that discovering contraband could somehow validate the unconstitutional search that discovered it. James used that opportunity to ask a series of questions captured by his phone that officers hadn't confiscated because it was on the floor where he had dropped it when forced down. James asked what the specific probable cause was, who the anonymous informant was, what verification had been done of the information before deciding to invade a private residence, whether Dawson had tried to obtain a warrant and been denied by a judge, which would explain why he was now attempting warrantless entry. Each question demonstrated sophisticated legal knowledge and created a record that would be devastating in subsequent litigation. Dawson responded vaguely, saying the information was confidential, and he didn't have to justify his investigative actions to James. But James pressed on, pointing out residents have absolute right to know the legal basis for searches of their homes, that the Fourth Amendment had no confidential information, exception permitting law enforcement to ignore the warrant requirement, and that Dawson's refusal to provide specifics strongly suggested there was no legitimate basis for the search. James also mentioned his house had comprehensive security system documenting everything happening, that his security company had been automatically notified of the alarm being disarmed under duress and probably had already contacted local police and possibly his law office, and that camera recordings were automatically backed up to cloud storage, so any attempt to confiscate or destroy recording equipment would be futile. The mention of multiple cameras and cloud backup made several officers look around nervously, apparently realizing for the first time their actions were being documented in ways they couldn't control or suppress. The search of James's house lasted approximately 45 minutes, during which officers rummaged through every room, opened every closet, overturned drawers, and generally treated his property with the carelessness characterizing searches when officers are frustrated at not finding what they expected. Security cameras captured everything. Officers throwing clothes from closets onto the floor, flipping mattresses, emptying bookshelves, creating disorder that would take James days to fully clean up. And through all of it, they found absolutely nothing illegal. No drugs, no paraphernalia, no contraband of any kind. What they found was exactly what you'd expect to find in a respected attorney's house: legal books, case documents, normal clothes, normal groceries, the completely mundane and legal life of a middle-class professional. The complete absence of anything incriminating should have been embarrassing for Dawson, but instead of admitting error and apologizing, he doubled down on his now completely discredited authority. Dawson informed James that even though they hadn't found anything this time, they had the right to conduct a search based on information they received, and that James should consider this a warning they would be watching him. James responded with icy calm that was now beyond anger, and in lawyer mode calculating exactly how big the lawsuit would be, that a warrantless raid producing no evidence of crime wasn't legitimate warning, but illegal harassment and Fourth Amendment violation, that there was no legal authority for the search they conducted, and that he would be filing formal complaint with every relevant oversight agency, including the FBI, considering this potentially constituted deprivation of rights under color of law, a federal violation with potential criminal consequences for Dawson, and any officer who participated, knowing the entry was illegal. The mention of FBI investigation finally made Dawson look less confident, but instead of apologizing or attempting to repair, he simply ordered his officers to leave. Officers removed James's handcuffs and began exiting his house, leaving damaged door hanging from broken hinges, cracked frame where the battering ram had hit repeatedly, and interior completely ransacked by the search. James immediately began documenting the damage, taking photographs and videos of every affected area, narrating for the record exactly what had happened and precise timestamp of each phase of the invasion. He also immediately called a partner at his law firm, a lawyer named Marcus Reynolds, who had worked with James on numerous police misconduct cases and who knew exactly how serious this was. Marcus said he'd be there in 20 minutes and that James shouldn't touch anything except document because they wanted to preserve the scene exactly as it was for evidence in subsequent litigation. James also called the private security company and confirmed they had all recordings saved and that he would need officially certified copies for legal use. News of what had happened spread through the local legal community with remarkable speed. James Carter, one of the state's best-known civil rights attorneys, had had his home raided without a warrant by sheriff's team in a search producing no evidence whatsoever. Fellow lawyers began calling, offering assistance, many of them shocked. Dawson would be foolish enough to execute a warrantless entry on the residence of a lawyer who literally wrote the book on Fourth Amendment rights. Some expressed a theory that maybe this wasn't a mistake, but intentional retaliation because James had successfully sued several law enforcement departments in the region, and maybe Dawson was trying to intimidate him or send a message. If that was the intent, it backfired spectacularly because instead of intimidating James, all Dawson had done was give him a perfect case with perfect video evidence and documented damages that would make a jury furious. Marcus arrived at James's house with 2 other lawyers from the firm, all of them immediately beginning to photograph and document everything, while James provided detailed chronology of what had occurred. They reviewed security camera footage right there, watching the forced entry frame by frame, noting every procedural violation, every moment where officers exceeded authority they didn't have in the first place. Marcus called a private investigator the firm regularly used, asking him to come immediately to document the scene and interview neighbors who might have witnessed the obvious tactical operation that had occurred in what was normally a quiet neighborhood. They wanted witness statements establishing there was no emergency, no noise or activity coming from James's house that could have created exigent circumstances, nothing justifying the warrantless entry Dawson had ordered. One of James's neighbors, a retired woman named Helen Martinez, who lived 3 houses down, came to his property after she saw officers leaving. She was visibly upset, saying she had seen the entire tactical operation unfold and was shocked this was happening to James of all people, that everyone in the neighborhood knew him as quiet, respectable, never any problem. She offered to testify about what she saw, and Marcus immediately took her statement while fresh in her memory. Helen described seeing tactical vehicles arriving, seeing officers in full combat gear, positioning around the house as if about to raid a terrorist hideout, hearing violent pounding on the door, and then the sound of battering ram breaking the entry. She said it seemed completely disproportionate and frightening that several other neighbors had also observed and were equally confused about why law enforcement was treating James this way. Marcus was already mentally building the case while documenting evidence. This would be a Section 1983 lawsuit for Fourth Amendment violation, clearly established jurisprudence, making it obvious that forced entry without warrant or exigent circumstances was unconstitutional. Qualified immunity wouldn't protect Dawson or the other officers because no reasonable officer could believe they had authority to do what they did. There would be claims for compensatory damages for physical damage to property, for emotional distress of having home invaded and being handcuffed in his own living room, for violation of privacy and dignity. There would be claims for punitive damages because the conduct was so flagrantly unconstitutional, it demanded punishment beyond mere compensation. And there would be claims against the county for failure to adequately train and supervise, because no properly trained department should have officers who think they can raid private residences based on unverified anonymous tips without bothering to obtain a warrant first. James filed formal complaint with the sheriff's department that same afternoon, a 23-page document meticulously detailing every constitutional violation, every deviation from standard procedure, every moment of the raid supported by timestamps from video recordings. He also filed complaints with the county's Civilian Law Enforcement Oversight Commission, with the FBI's Civil Rights Division, and with the State Bar Association, requesting investigation of possible ethical misconduct by prosecutors who might have advised Dawson about the legality of the planned entry. Marcus and the legal team began issuing evidence preservation letters to the sheriff's department, to the county, and to any other entity that might have relevant records, putting them on formal legal notice that litigation was imminent and any destruction or alteration of evidence would be considered spoliation with severe sanctions. They wanted Bodycam recordings from all 8 officers, radio dispatch records, any incident reports or internal memos, records of the source of the alleged anonymous tip, everything that could shed light on how this operation was planned and authorized. The sheriff's department's initial response was defensive and evasive, exactly the kind of posture James had seen dozens of times in previous cases when departments knew they had made a mistake but were still trying to minimize liability. The department's spokesperson issued a statement saying officers had conducted a routine investigation based on credible information that the resident hadn't fully cooperated and that the search was conducted according to appropriate procedures. Every part of that statement was either factually incorrect or legally misleading, and James and Marcus immediately issued a public response dismantling each claim. They pointed out that battering ram raid of peaceful citizens' home without warrant wasn't routine investigation, but grave constitutional violation, that James had every right not to cooperate with illegal search, and that appropriate procedures required a warrant Dawson never bothered to obtain. They included a statement offering to make video recordings available to any interested reporter, knowing media would love the story of sheriff's department illegally raiding prominent civil rights attorney's home. Media coverage began within 48 hours of the raid, with local news running segments showing clips from security camera recordings, synchronized with doorbell camera footage, seeing the door being broken down by battering ram, seeing James being handcuffed in his own living room, seeing officers ransacking the house and finding nothing. All of it created a powerful visual narrative that made the public immediately sympathize with James and question Dawson's judgment. Civil rights organizations issued statements condemning the raid and citing it as an example of why law enforcement reform was necessary. The local bar association issued an unusually strong statement expressing serious concern about law enforcement raiding a bar member's residence without warrant, noting this raised questions about whether James was being targeted for his work suing police departments. Public pressure on the county and sheriff's department began building rapidly. The County Board of Commissioners, confronted with disastrous public relations and prospect of expensive lawsuit from lawyer who rarely lost, convened emergency meeting to discuss the situation. They consulted with county attorneys who reviewed available evidence and gave a grim assessment of the county's chances in any litigation. The lawyers pointed out James had video evidence from multiple angles showing forced entry without warrant, that he had independent witnesses. That case law was clear, such conduct violated the Fourth Amendment, and that as an expert constitutional attorney, he would know exactly how to present the case to a jury in maximally damaging way to the department. More worryingly, from the county's perspective, James had a history of winning cases against law enforcement and obtaining large verdicts or settlements, and reputation for not accepting small settlements just to make cases go away. He typically fought for real accountability, including policy changes and officer discipline, not just payouts. Dawson was placed on administrative leave pending internal investigation, an action the department presented as standard procedure, but everyone understood to be first step toward more serious consequences. The 8 officers who participated in the raid were all interviewed by internal affairs investigators, and their accounts began to diverge in ways suggesting not all were comfortable with what had happened. Several officers admitted they had questioned the wisdom of forcing entry without warrant, that they had expressed concerns to Dawson about legal authority for the search, but had been told by the sheriff he knew what he was doing, and to follow orders. Those admissions would be crucial for establishing Dawson hadn't just violated James's rights, but had done so despite warnings from his own officers, demonstrating deliberate recklessness rather than mere error in judgment. The FBI investigation into possible deprivation of rights under color of law officially began 3 weeks after the raid, with federal agents contacting James for detailed interview and requesting copies of all his evidence. FBI took these investigations seriously because federal statutes made it a crime for law enforcement officers to intentionally violate citizens' constitutional rights. And the evidence in James's case was so clear, federal prosecutors were genuinely considering criminal charges against Dawson. James cooperated fully with the federal investigation, providing comprehensive chronology, all video recordings, documentation of damages, and list of witnesses. He made clear to FBI investigators he wasn't seeking personal revenge, but systemic accountability, that he wanted to ensure other citizens wouldn't be subjected to the same treatment he'd experienced. Marcus began assembling depositions from experts who would testify about standard law enforcement practices, constitutional requirements for searches and seizures, and typical emotional damages from having one's home raided by armed tactical team. One expert was a former police chief from a large urban department who had implemented extensive reforms and was prepared to testify no adequately trained department should have officers conducting forced entry without warrant based solely on unverified anonymous tip. Another expert was a psychologist specializing in trauma from violent law enforcement encounters, prepared to testify about long-term impact of having home invaded and being treated as criminal in one's own personal space. James would also serve as his own expert to some extent, his extensive experience litigating police misconduct cases qualifying him to testify about how the raid of his home compared to other cases he'd litigated and why it was so obviously unconstitutional. The civil lawsuit was formally filed 4 months after the raid, a masterful legal document of 117 pages that would eventually be used as an example in civil rights advocacy courses on how to build an airtight police misconduct case. James and Marcus named Dawson individually, the 8 officers who participated in the raid, the sheriff's department, and the county as defendants, alleging Fourth Amendment violations, illegal entry, unreasonable search and seizure, failure to train and supervise, and intentional emotional distress. The petition included exhibits with selected frames from video recordings, transcripts of relevant dialogue, photographs of property damage, witness statements, and detailed legal analysis of each violation. The requested damages amount was $5 million in compensatory and punitive damages, a sum that made headlines, but which James's lawyers argued was appropriate given the flagrancy of the misconduct and the need to send a message that such obvious constitutional violations would have severe financial consequences. The defendant's response was exactly what James expected, a mix of technical denials, attempts to invoke qualified immunity, and arguments that officers had acted in good faith based on information they had at the time. But these defenses were extraordinarily weak given the factual record. Qualified immunity doesn't apply when officers violate clearly established rights any reasonable person would know. And the right to be free from forced entry into home without warrant or exigent circumstances was one of the most fundamental and clearly established principles in all constitutional jurisprudence. The good faith argument was similarly difficult to sustain when James had recordings of himself literally warning Dawson the entry would be illegal and citing specific cases before the door was broken down. Defense attorneys knew they were holding a losing hand, but had an obligation to represent their clients as vigorously as possible while trying to minimize financial damages. The discovery process revealed information that made the case even worse for defendants. The alleged anonymous tip Dawson had used to justify the raid apparently came from an unverified phone call to the department's crime tip line, where an unidentified caller alleged drug activity at James's address, but provided no specific details, no basis of personal knowledge, no description of observable behavior suggesting criminal activity. Call records showed the tip had been received at 3:47 a.m., and Dawson had organized the raid for 6:47 same morning, giving himself exactly 3 hours to plan and execute forced entry without apparently making any effort to verify information, conduct surveillance, check James's criminal records, or consult with a prosecutor about whether he had legal basis for warrantless entry. Any of these basic steps would have revealed James was a respected attorney with no criminal record, and that anonymous tip alone provided nowhere near sufficient probable cause to justify forced entry. More damaging, internal emails between Dawson and his officers revealed at least 2 tactical team members had expressed specific concerns before the raid about lack of warrant and questionability of information, but Dawson had dismissed those concerns and ordered them to proceed anyway. An email from veteran tactical officer named Robert Mills explicitly said, "Sheriff, respectfully suggest we obtain warrant before executing forced entry. Information is vague and we have no independent verification. Warrantless entry into residence without clear exigent circumstances creates significant liability." Dawson had responded to that email with, "Appreciate concern, but I have authority to make this call. We proceed as planned." That email exchange was pure gold for James's case because it showed Dawson hadn't just violated constitutional rights, but had done so despite explicit warning from subordinate officer about illegality of planned conduct. Depositions of the 8 officers provided additional testimony damaging to defendants. Several officers admitted under oath they had felt uncomfortable with lack of warrant, that this wasn't how searches were typically conducted, and that they had been surprised when Dawson ordered use of battering ram after James refused to consent to entry. Officer Mills, who had sent the warning email, testified that in his 17 years in law enforcement, he had never participated in forced entry without warrant into residence, where there were no obvious exigent circumstances like ongoing violence or evidence being destroyed. He described observing James through a window during the search and realizing this wasn't typical drug raid scenario, that the house was clean and well maintained, that James was articulate and knowledgeable, and that complete absence of any contraband confirmed his initial concerns that raid had been ill-advised. From the start, Dawson's deposition was a disaster for the defense. Confronted with video evidence, internal emails, and testimony from his own officers, he tried to defend his decisions, but ended up appearing arrogant and dismissive of constitutional limits. When asked why he hadn't obtained a warrant given he had several hours between receiving tip and executing raid, Dawson responded he didn't believe warrant was necessary because he had probable cause. When Marcus pressed about why he considered unverified anonymous tip as establishing probable cause, Dawson became evasive and defensive. When confronted with transcript of James literally warning him entry would be illegal and citing constitutional cases, Dawson dismissed that, saying, "Citizens frequently claim law enforcement has no authority even when it does," completely missing the point that James wasn't an ordinary citizen, but legal expert who knew exactly what he was talking about. The county attempted settlement multiple times. During discovery process, starting with offer of $250,000 that James rejected without counteroffer, sending clear message he wasn't interested in small settlement that would allow county to avoid real accountability. As more damaging evidence emerged through discovery, county settlement offers increased: $500,000, $750,000, $1 million. But James remained firm. He wanted more than money. He wanted Dawson permanently terminated and law enforcement certification revoked. He wanted departmental policy reforms, including mandatory training on Fourth Amendment requirements, increased oversight of all forced entries, and early warning system to identify officers with patterns of problematic conduct. He wanted independent civilian review board with real authority to investigate complaints and recommend discipline. In short, he wanted exactly the kind of systemic accountability he had fought for in countless previous cases, and now he had the perfect case and personal motivation to ensure he got it. The case was finally resolved through a comprehensive settlement 14 months after the initial raid, a settlement going far beyond simple financial compensation and representing one of the most significant police accountability victories in the state's recent history. The county agreed to pay James $1,200,000 in damages, an amount reflecting both the gravity of the constitutional violation and recognition that taking the case to trial would likely result in an even larger verdict given how clearly prejudicial the evidence was. But the money, while substantial, wasn't the most important part of the settlement for James. The structural reforms mandated as part of the settlement would transform how the sheriff's department operated and potentially prevent future similar violations. Dawson was permanently terminated and his law enforcement certification revoked by the state, effectively ending any possibility of him working in law enforcement again. The 8 officers who participated in the raid received unpaid suspensions ranging from 30 to 90 days, depending on their level of participation and whether they had expressed concerns before the entry. The settlement required creation of an independent search review unit within the Sheriff's Department, composed of senior officers and outside legal consultant, that would have to approve any planned forced entry into residence before it could be executed, unless genuine exigent circumstances didn't allow time for prior review. The unit would have to verify either a valid warrant existed or clearly articulable exigent circumstances justified warrantless entry, and their decisions would be documented in writing with specific legal reasoning. Any forced entry conducted without prior approval from this unit would automatically result in investigation and potential discipline of the commanding officer. The settlement also mandated quarterly mandatory training for all officers on 4th. Amendment requirements with curriculum developed by outside constitutional experts, including review of real cases where departments had been held accountable for violations, specifically including James's own case as an example of what not to do. A civilian review board was established with real authority rather than merely advisory role, composed of 7 community members, including at least 2 lawyers with constitutional law experience, a mental health professional, and representatives from communities historically experiencing over-policing. The board would have subpoena power, complete access to Bodycam recordings and incident reports, and authority to make binding recommendations on officer discipline in cases involving allegations of constitutional violations or excessive force. Board members would receive comprehensive training on relevant legal standards and best practices in law enforcement oversight. The department was required to respond publicly to all board recommendations within 30 days, and if it rejected a recommendation, had to provide detailed written justification made available to the public. The settlement included provision requiring the department to collect and publish quarterly data on all searches conducted, including whether warrant was obtained, race of person whose property was searched, result of search, and whether any force was used. This data would be analyzed by independent statistician to identify any patterns of racial disparity or other systemic concerns. If analysis revealed problematic patterns, department was required to conduct complete audit and implement corrective measures. All officers were required to wear body cams during any search or entry onto private property, and recordings had to be preserved for minimum 3 years and made available to residents upon request, unless there was specific legal reason to withhold, with any denial subject to review by civilian review board. Failure to record when required would create rebuttable presumption officer had acted improperly. Widespread media attention to the case and subsequent settlement created ripple effect through other law enforcement departments in the region. Departments in 3 neighboring counties voluntarily implemented similar policies requiring prior approval for forced entries and increasing search oversight, wanting to avoid finding themselves in similar situation to James's county. The State Bar Association used the case as basis for series of continuing education seminars on Fourth Amendment rights and police accountability, with James and Marcus serving as instructors and the raid video being shown as example of multiple procedural and constitutional violations. Law schools across the state incorporated the case into their civil rights curricula, using it to teach both effective civil rights advocacy and importance of documenting violations through video and other objective evidence. James used significant portion of the settlement money to expand his law firm's civil rights practice, hiring 2 additional associate attorneys specifically to focus on police misconduct cases and establishing a fund that would provide pro bono or reduced fee representation for victims of constitutional violations who couldn't afford standard legal fees. He also donated $250,000 to local nonprofit organization providing civil rights education training for communities of color, wanting to ensure more people understood their constitutional rights and how to document violations if they occurred. In interviews about the case, James always emphasized he'd been fortunate to have legal knowledge, resources to hire good additional lawyers, even being a lawyer himself, and security system capturing undeniable evidence. He pointed out most victims of warrantless entries and other law enforcement violations didn't have these advantages and often couldn't obtain justice even when their rights had been Clearly violated, the FBI's criminal investigation of Dawson for deprivation of rights under color of law continued separately from the civil lawsuit and eventually resulted in federal charges. Dawson pleaded guilty to reduced misdemeanor of improper official conduct to avoid felony trial with possible prison time. But even that misdemeanor charge included 2-year probation period, substantial fine, and permanent prohibition from serving in any law enforcement capacity. The criminal prosecution sent a message that flagrant constitutional violations weren't just civil matters resulting in money payouts, but could be crimes with serious personal consequences for officers committing them. Some law enforcement advocacy groups complained punishing Dawson so severely would have chilling effect on officers doing their job. But most commentators, including many in law enforcement, pointed out that avoiding raiding someone's home without warrant based on unverified anonymous tip wasn't particularly high standard, and officers who couldn't meet that basic standard probably shouldn't be in law enforcement. The Civilian Review Board established as part of the settlement proved more effective than even proponents had hoped. In its first 3 years of operation, the board reviewed 63 complaints of police misconduct, sustained 29 after complete investigation, and made recommendations resulting in 5 additional terminations, 18 suspensions, and mandatory remedial training for 47 officers. More importantly, the presence of independent oversight with real authority changed culture within the department. Officers knew their actions were being monitored by civilian body with power to recommend real consequences, and this created incentive to follow appropriate procedures and respect constitutional rights. Number of complaints about problematic searches dropped 61% in 3 years after implementation of reforms. And public satisfaction with department, as measured by regular surveys, improved significantly. James continued practicing civil rights law, his reputation strengthened by the fact he didn't just talk about constitutional rights, but had defended them personally when his own rights were violated. He became a sought-after consultant for other law enforcement departments, wanting to implement reforms voluntarily before being forced to do so through litigation. His house was completely repaired, but he kept all original security recordings of the raid as memento and teaching tool. He occasionally showed clips and presentations to community groups and law enforcement training sessions, using his own experience to illustrate why respect for constitutional rights wasn't just legal requirement, but moral imperative. His twin daughters, who had been too young to fully understand what happened when their house was raided, grew up hearing the story of how their father had transformed terrible violation into opportunity for systemic change benefiting countless others. The red door broken down by battering ram was eventually replaced, but James kept pieces of original damaged frame in his office. As physical reminder, even expert constitutional lawyers weren't immune to having rights violated, but also as symbol accountability was possible when victims had knowledge, resources, and determination to fight. Fellow lawyers frequently commented on those pieces of damaged frame displayed prominently, and James used them as starting point for discussions about importance of documenting violations, knowing your rights, and persisting through often long, frustrating process of seeking justice against powerful institutions with every incentive to avoid accountability. He told young lawyers greatest lesson from entire experience wasn't that system always worked, but that it could be made to work when you had right evidence, right legal arguments, and refusal to accept injustice even when it would be easier to simply move on. 10 years after the raid, academic researchers studying effectiveness of police oversight reforms contacted James for interview as part of longitudinal study. Researcher had analyzed sheriff's department data and found reforms mandated by James's settlement had produced sustained measurable improvements in constitutional compliance, reduction in complaints, and increase in public trust. More significantly, reforms had been maintained and actually expanded over time, rather than gradually eroded, suggesting they had created real cultural change rather than just superficial compliance. James expressed cautious satisfaction with those findings, noting one successful case in one county didn't solve national problem of police misconduct, but each victory contributed to larger cumulative change and provided model others could follow. He remained committed to work of holding law enforcement accountable when it violated constitutional rights, motivated by both professional conviction, and personal knowledge of how it felt to have your own rights trampled in your own home. James's story became more than just legal case or civil rights victory. It became narrative about power of persistence, importance of knowing your rights, value of documenting everything, and possibility of transforming traumatic experience into catalyst force for systemic change. It became about what happens when law enforcement chooses wrong person to harass, but more importantly, about what should happen in every situation where constitutional rights are violated, regardless of who the victim is. The irony of Sheriff's Department raiding leading constitutional lawyers' home wasn't lost on anyone. But the real lesson was every person deserved protections James had been able to vindicate for himself. And justice system should work equally well for ordinary citizen without legal knowledge as it worked for expert who knew exactly how to navigate complexities of civil rights. Litigation. The $1 million settlement made headlines, but true measure of success were reforms still in place years later, still protecting residents' rights and still serving as model for other departments trying to do better.